The Honorable United States Court of Appeals for the First Circuit is now in session. All persons having any business before this honorable court may give their attendance, and they shall be heard. God save the United States of America and this honorable court. Court is in session. Today's cases will be called as previously announced, and the times will be as allotted to counsel. The first case today is United States versus Ryan Mumme, appeal number 19-1983.
Ms. Davis.
Yes. Good
proceed.
morning. Good morning. May it please the court, I'm Mary Davis, and I represent the appellant Ryan Mumme. The issue I would like to address this morning is whether Mr. Mumme's consent to the seizure of his computer was voluntary. As noted in our opening brief, the burden of proving voluntariness is on the government. Moreover, we submit that the decision of the district court was clearly erroneous based on the facts. There are three factors that the court is to consider when looking at a consent issue, and that is whether the individual had knowledge of his right to refuse consent, any possible vulnerable subjective state of the consenting party, and whether there are inherently coercive tactics other than in the nature of the questioning or in the nature or the environment in which the questioning took place. Here, obviously, Mr. Mumme knew he had the right to refuse consent because he did so early on and pretty much throughout the conversation with the officers. But when Mr. Mumme said, "I want to call an attorney, can I go into the house to make a call?" The officer refused to allow him to go into the house to call an attorney. Immediately thereafter, I would say less than a minute later, that is when Mr. Mumme consented to the seizure. The officers accompanied him into the house and they seized his computer. We submit that the failure of not allowing Mr. Mumme to use a phone to call his attorney was what led to him consenting to the seizure, and that this was not a voluntary consent. The district court found it was not coercive to not let Mr. Mumme in to make the call because he could have used a cell phone. But there's absolutely nothing in the record to indicate that anyone had a cell phone that Mr. Mumme could have used. In addition, there are a couple of cases we cited in our brief, Milo and Illinois v. MacArthur from the Supreme Court, where they noted that the fact that the suspect was able to go in and out of the house with an officer, or the individual, the suspect, was being questioned while an attorney was listening in, and the person had the opportunity to talk with his attorney. This shows that in this case, it was not necessary for Mr. Mumme to be kept out of his home to use the telephone.
Can I ask you a question?
Yes.
One way to read the record, you tell me if this is a permissible way to read it, is that they are worried about him going in alone to the house because he might destroy the evidence.
Correct.
And so it's clear to him that they could go in and just take the electronics, but if they don't want them to do that, then they need to work out something, which will involve either him not going in the house on his own and waiting, or him going in himself and handing it over to them.
When there was a third option for them to accompany him into the house so he could use the phone to call an attorney.
Excuse me, but go ahead, Judge Barron, then I have questions.
I see that that's a possibility. What I'm just saying is if one of the options, what they were saying to him is all of this is conditioned on, we could just go in and take the electronics, then I don't really understand what the problem is, unless you're saying that was not offered to him as an option.
It was offered to him as an option if he consented to it. Yes. If he consented to the seizure, they could go in and take it.
I thought there was a statement that says we could seize your house or the electronics. That's all I thought said without saying I need a warrant to do that, because wouldn't they have probable cause to go in because of the risk that the
I
stuff would be
think
destroyed?
they could have kept the house, they could have kept Mr. Mumme and his family or anyone else from going into the house while they got a warrant to seize the computer. That was an option, but I don't believe they could have gone in to just seize the computer, because clearly, it's my reading of the record and my reading of the affidavit by the officer is that when they first went to Mr. Mumme's home, they did not have probable cause to get a warrant to seize the computer. If you look at the search warrant, there's nothing in there, no incriminating statements regarding Mr. Mumme, other than he sent $30 to someone at one point in time. And
Ms. Davis, you
Yes.
did raise the lack of probable cause argument in the district court. The district judge ruled against you and found that the officers had probable cause at least as of the time of the conversation with him that you are relying on. You have not appealed that determination. So we take it as a fact that they had probable cause, or they reasonably believed they had probable cause at that point when they said, you know, the option for us is we go get a warrant. And given they had probable cause, there's a lot of case law, including from our circuit, U.S. versus Vasquez, U.S. versus Lee, U.S. versus Miller, that says consent is not vitiated when the officers say that the alternative is they'll go get a warrant.
That's correct. That's very true. But my point is, in this instance, in this case, that without even looking at the warrant, putting that aside, because that was not, I don't believe that was raised below, that there was no probable cause. I believe the
4
judge.
minutes left.
Thank you. I believe the district court judge did find that, but that was not raised in the motion to suppress.
Okay, then what precisely is the argument of involuntariness if there's nothing wrong with the officers saying, look, the alternative to your consent is we just freeze this and we go get a warrant?
Well, that's correct. And so, right, but I think the important factor is that Mr. Mumme wanted to call an attorney. And it was only when he was refused that did he say, okay, just go ahead and take it.
He wasn't refused the opportunity to get a lawyer. He just wasn't offered a telephone. I mean, he could have asked for one. I mean, are you saying that when somebody says I want to make a call, that it's incumbent on the police officers to make all his options for making that happen clear to him?
I believe it is. Yes, I do. The district court judge said, well, he could have used a cell phone. No one knew if anyone had a cell phone. No one knows that that was an option. And the burden is not on Mr. Mumme to establish the facts. The burden was on the government, and the government didn't produce any evidence whatsoever that this was an option for Mr. Mumme.
Did he follow up? If I can't go in the house, how can I get a lawyer then?
No, he did not. He was just refused entry into the house to call a lawyer. And immediately after that, that's when he consented.
What would be wrong with saying that the rule is that if the defendant feels at that point that they're being denied a lawyer, they need to make that known? Because if known, maybe they would have made an option for him to make an arrangement to make a call other than going into the house, given they had a very reasonable reason to be worried about him going into the house to do it.
Right, but I mean, again, I go back to my original point that they could have accompanied him into the house. There was nothing stopping them from going into the house with him so he could make his call.
Oh, yes, there was. They thought that the wisest course was to go get a warrant. And how can that, under those circumstances, render your client's consent involuntary? You seem to be assuming that the police have to offer cell phones to people when they say, no, you can't go into the house.
I think that should be something that should have been presented, an option presented to Mr. Mumme. And also the other point I wanted to bring out, not just the fact that he wasn't given a phone to call, but the fact that his father, it's obvious he was very close, had a close relationship with his father. His father was told not to hinder on 2 occasions. And his father Officer Tupper agreed during the motions hearing that that Mr. Mumme's father was restricted. He was not allowed to go over towards Tupper and Ryan. And I think that this added to the coercive nature of the environment during the questioning.
Okay, so you're making 2 points. One is about the father not being there to help his adult son make a voluntary decision. And the other is the cops should have given him a cell phone when they said, no, we're not going to let you go into the house right now.
Right. I think the fact, just because Mr. Mumme was, I think at the time, 46 years old, does not mean that he did not feel overwhelmed and afraid. In fact, one of the officers testified that he was very scared.
Finish your sentence, Ms. Davis.
And the officer testified that Mr. Mumme was very scared, and the officer testified that the father's movements were restricted.
Okay. Thank you.
Thank you. If you could mute your device, please, Attorney Davis, and Attorney Block, if you could unmute your device.
Good morning. May it please the court, Benjamin Block on behalf of the United States. I'll pick up this discussion about the potential obligation of law enforcement to provide a cell phone, because Judge Lynch anticipated my argument entirely, which is that Mr. Mumme's argument is predicated on
Mr. Block, I did not make your argument. I asked some questions. Could you reframe it, please?
Absolutely. Your question touched on an argument that I wish to make, which is that Mr. Mumme's argument is based on a flawed assumption that law enforcement had some obligation to assist Mr. Mumme in making a phone call at the time that they secured his home. They did not. There was no Sixth Amendment right to counsel at that point in the investigation. Mr. Mumme had not been charged with any crime. There was no Fifth Amendment right to counsel. Mr. Mumme was not in custody, and he was not even being interrogated at the time of the consent. And even if this was a situation in which there was questioning, an invocation of counsel in the interrogation setting only requires the police to cease questioning. It doesn't require them to cease all other investigative steps. So the issue here is whether the police had an affirmative obligation to assist Mr. Mumme in reaching counsel, and there's simply no basis for that in the law. Instead, they presented.
Understand one thing that I just need to be, I think, apprised of what the case law is in this area. So let's take as a given that they had probable cause at the time of the conversation to seize the computer.
Yes.
That's how you think we should be taking as a baseline, correct?
Correct.
Yeah. Now, as I understand it, the officers were under the impression that they still needed a warrant to search the computer, independent of the right to seize it, or is that wrong or right?
They needed a warrant both to search the computer, and they needed a warrant at that point to enter the home in order to seize the computers, because Mr. Mumme to that point had declined to consent to the seizure.
Okay, so your view even though they had probable cause and even though they were worried about its possible destruction, they did not have authority at that point to go in to get the computer.
No, their only authority at that point was to prevent the destruction of the evidence. And that's why they had the lawful right to secure the home. And if you look at the conversation on page 59 of the joint appendix between the officers and Mr. Mumme, they say, they begin by saying, we can seize your house, and he's concerned about that. And then they clarify, no, we can secure your house while we go get a warrant. And I think that was a correct understanding of the law on the police officer's part, that they couldn't enter the home without his consent, but they could secure the home to prevent anyone from entering it in order to preserve the evidence. And that comes from the Supreme Court decision in Illinois versus MacArthur.
Okay.
And MacArthur also makes clear that the broader right of law enforcement in this situation is to completely secure the home. And the fact that in MacArthur, the officers accompanied the defendant in to make a phone call, the Supreme Court refers to that as a lesser, as the lesser being within the greater, and the greater right was to secure the entire home. So law enforcement here isn't obligated to use least restrictive means to preserve the evidence. They felt that the appropriate thing was to secure the home in the absence of consent to seize the evidence. And so the only relevance of this question of Mr. Mumme's request to make a phone call, which I would note, he didn't even specifically say, I wish to call a lawyer. He just said, can I go into the house to make a call? But assuming for purposes of argument that his intent was to call a lawyer.
I take it, did MacArthur address anything relating to voluntariness of a consent that occurs in that circumstance?
No,
I assume,
that was purely a seizure.
Here's the puzzle. If they had seized him and then asked for his consent, we'd question whether the consent was voluntary, correct?
Correct. If he were in custody or restricted, yes.
Now we've seized your house and say you can't go in it. And yet we're supposed to think that, notwithstanding that's happened to him, his consent is voluntary. What's your best case for saying that after they've told you you're going to be kept out of your house, your decision to give up an item in the house as a price of entry into it is a consensual act?
Well,
5 minutes remaining.
Thank you. I would point the court to the Twomey decision and Perez-Montanez, both from the First Circuit and cited in our brief, that when law enforcement describes two valid options.
But in either of those cases, was the person who's consenting being told that one of the option was you're going to be kept out of your house for maybe a night?
I'm not sure, but if it's lawful under MacArthur to do so, then it's not.
It's lawful to seize the person. See what I'm. Just let me just finish this line of questioning.
Yeah.
It's perfectly lawful to seize a person, and yet when you supposedly consent when seized, we don't treat it as a voluntary consent. I guess I'm asking, what is the logic of saying when we say we're going to seize your house unless you consent to give us something in it, that's also consensual?
I think law enforcement has the right to preserve evidence, and if that comes at some inconvenience to the defendant, then the defendant is allowed to choose between his own inconvenience and law enforcement's right to preserve evidence for an investigation. And so here, Mr. Mumme made a valid choice between two lawful options, and he chose the one that was less inconvenient to him, with the full understanding that the police still needed to go get a warrant in order to search the computers. So the only thing. Yes,
you know, Mr. Block, I had the same questions that Judge Barron did as I prepared for this case. We have dealt with this issue, U.S. versus Vasquez, 724, Fed Third 15, U.S. versus Lee, 317, Fed Third 26, and indeed going back to U.S. versus Miller in 1978, 589, Fed Second 1117. I don't believe either party cited to these cases a regrettable omission, but that's what my research showed.
Your Honor, we did cite to the Miller decision, but we did not cite to Vasquez or Lee, and I do apologize for that.
Is Miller this situation in your view, Mr. Block?
Miller addresses the question of a defendant being put to hard choices between two lawful choices, and it notes that asking a defendant to choose isn't coercive.
But was the choice there, stay out of your house for 24 hours or give us your computer? In other words, at some point, the question is any choice that you put them to that's lawful, non-coercive? Maybe the answer is yes. Or are there some choices that you put them to that constitute coercion?
Well, I think that clearly in this case, the choice was not coercive. And so rather than speculate as to whether there are circumstances in which it might be a coercive but lawful choice, I would say here you have a 46-year-old man who fully understands his right to refuse consent, and has had a non-hostile conversation with law enforcement, and law enforcement has been very upfront with him about their options at that point, which all include going to a judge to seek warrants. I think in that circumstance, there's simply nothing in the record to suggest that it was involuntary, and even less in the record to find that the district court's finding of voluntariness was clear error.
Counsel, didn't they in fact go get a warrant so they could search the computer once they got it?
Yes, they did.
And how long did that take? Wasn't that done that same afternoon?
I am not sure, but the officer did state to Mr. Mumme that his choice was either to go see a judge that day for a warrant for the house or the next day for a warrant for the computer. So
That's
I think, thank
Okay.
you. So I think, thank you. So we would ask the court to affirm on all, affirm the decision. Thank you.
Thank you both.
That concludes the argument in this case. All right. Let's see. The next case today is United States versus Scott Estes, appeal number 192111. Attorney Andrews, proceed.
May it please the court, Judge Lynch, Judge Barron, Judge Burroughs, I'm requesting 2 minutes for rebuttal.
Certainly.
Okay. Your Honors, may it please the court, this case involves the Sixth Amendment right to confrontation, and specifically the primary purpose test and the literal right to confrontation. Mr. Estes asserts that the district court misapplied the objective part of the analysis from Ryan. In particular, the focus should have been not just on the emergency, but also on the investigation that was done by the caller. I lost everybody and I'm frozen. I'm gonna call my phone. I'm gonna call on the phone. Someone beginning to ask me a question and
No, proceed with your argument.
certainly
You were saying the focus should have been on
the investigation done by the caller and not on the emergency itself. The investigation on the caller is an objective circumstance, a fact that was proven, and evidence was submitted with respect to the investigation that was done by the caller to the 911 emergency line. That investigation involved contacting not one, but two other people and inquiring about various circumstances that may have made Mr. Estes' conduct more or less illegal. Because the district court judge did not address this sufficiently and focused more on the subjective motivations of the police and the objective or the subjective fear of the caller, that an opposite outcome should have occurred in this case. While we understand why...
Mr. Andrews, I want to be clear. A redacted version of the call was put in, such that, as I understood it, by agreement, some of the information about the investigation was redacted. Okay, so given that background, is your argument that this wasn't really an emergency because before she got on the 911 call, she contacted friends, and in the course of contacting those friends, she urged both of them to notify the police of the situation she was in?
It is a part of my argument that there was not a true emergency here because of those contacts. She didn't call the police, I need help, there's a man that I'm with who has a gun and he's using that gun recklessly in a way that puts me in fear.
Okay, but the government argues she was not free to make a voice 911 call until they came upon a road emergency, roadblock or something, and he got out of the car. And as soon as he got out of the car, she then placed the 911 call.
I understand that the circumstances are such that it would be reasonable, right, as an explanation that Mr. Estes had gotten out of the car and she was finally free to make the call. She was texting and driving. It wasn't like that it was her actions were unnoticed by Mr. Estes. And you can sort of...
I'm sorry, are you saying if it were a real emergency, she should have texted the police rather than waiting to make a 911 call?
either the police or even just texted
4
her
minutes
friends,
remaining.
I need help because of this problem. That's not what she did. What she did was say to her employer, do you have a gun? And are you missing a gun? And does it look like this? And when the answer was in the affirmative, that's when she said, oh, I'm in trouble. And I would like you to call the police. And of course, that person did call the police. And then 10 minutes later, there was another call from the woman who was in the car with Mr. Estes.
By your account, Mr. Andrews, the questions that you just said that she asked are questions that are designed to figure out her degree of danger. So how does that help you?
Well, I don't think that those are questions to figure out her degree of danger. I mean, there's a gun. And
you were ending it by saying after she asked those, then she realized, now I'm in trouble.
well,
That's that's how you put it, which I think would be a fair construction of it. And that's a little different than an investigation. That would seem to be sussing out one's circumstance of threat.
And well, that is another objective criteria with respect to whether there's an emergency or not. I guess my point is, Judge Barron, is that the interpretation of the emergency is just a single factor with respect to whether or not these statements are testimonial, right? I think that there's a more significant factor involved here. And I want to move on to the idea that this is the literal right to confrontation that is involved here. It is both the investigation and the lack of emergency, and the fact that somehow, because if we look at Ohio versus Clark, which I didn't cite in my brief, but if I were to look at it, we would see that one of the major concerns in whether or not the primary purpose test is made is whether or not the person is capable of fabricating the emergency. And that is what we argued below, was that this was a fabrication of an emergency. But in more than that, the government sought to admit this testimony even though the declarant was available. And we think that that is a violation of the literal right. That is what Justice Thomas talks about in Davis, that the main focus of the Sixth Amendment right to confrontation is to avoid the prosecutorial
Mr. Andrews, the way you structured your brief, you first said there was a violation of the Sixth Amendment right, and then you make an argument that independent of the Sixth Amendment, there is a right to confrontation. The government says there is no such right as to your second argument. Would you like to address the government's assertion?
Certainly, Your Honor. I think that Justice Thomas describes that right quite clearly in his, I want to say, concurrence with Davis. He characterizes that there is, in fact, a literal right to confrontation, and that the informal nature of the 911 call can assume the basis of formality based on the idea that if someone is trying to evade, right, the formality of the process, that itself is a consideration in whether or not the statement should be admitted as testimonial or non-testimonial. And that, to me, is the crux of the literal right to confrontation. I think that's how Justice Thomas characterizes it. I think that's how Justice Scalia had characterized it in his concurrence in Ohio versus Clark.
Okay.
The other point that I would like to make, Your Honor, is that I think that, and I apologize if I mispronounced this, I think it's Cadu, the case that we all cite about the First Circuit's decision about what factors should be used in determining whether this is testimonial under Davis.
Go ahead, finish the sentence.
Sure. I think that those factors are unnecessarily restrictive, and that the factors are actually more inclusive than are identified in Cato. Thank you.
Thank you.
Mr. Andrews, if you could mute your device at this time. And Attorney Lopez, if you could unmute your device and proceed. Mr. Andrews, you're still on the screen. There you go.
Proceed, Ms. Lopez.
Thank you, Judge Lynch. Good morning. May it please the court. Julia Lopez on behalf of the United States. It's our view that the 911 call here is a quintessential example of a call made to seek assistance for an ongoing emergency. And I'd like to pick up on my colleague's argument that this wasn't really an emergency because the caller had done some what he calls investigation before she called 911. We've made two primary points in our brief as to why that doesn't change the fact that this was an emergency. The first being that the record shows that she was unable to make a voice call to 911 when this interaction with the defendant and the gun began. She was right next to him in a vehicle. He was brandishing a loaded weapon at her. And so she reasonably made the decision, I would argue, that it wasn't safe to call 911 and report him while he had a loaded gun in her presence. In addition, the text messages, and Judge Barron, you asked a question that touched on this. The text messages, I would argue, did two things. She did ask both people she texted to contact the police. She told one of them, I'm scared, I'm going to be hurt, please contact the police. So they certainly don't suggest there wasn't an emergency, but rather the opposite, that she's already quite fearful, and reasonably so. But also she's trying to assess just how much danger she's in. And as we argued in our brief, there's, I think, a difference between someone who's possessing a gun that they were given with permission by, a friend or something like that, which is what the defendant told his girlfriend, and someone who's actually taking the step of stealing a firearm that very morning. Already we can tell from the record that he's acting erratic, and so I would suggest that she's just trying to figure out exactly how much danger am I in through these text messages. And so it's our view that the district court was absolutely correct, that there's nothing about this approximately 20-minute period before she called 911 that diminishes the urgent and emergent nature of this call. And then my colleague has just suggested that the Kaju factors are too restrictive. Those factors are drawn directly from the Supreme Court's decision in Davis. They've been the law in the circuit for a long time. And as we've argued in our brief, this 911 call met each of those four factors, namely that the declarant was speaking about events in real time as they're actually happening. She's describing to the police exactly what's happening and the risk that she's in. A reasonable listener would conclude that this was an emergency. You have a felon with a loaded weapon who's brandished it at his girlfriend and who's stolen it that very morning. Third, that the dispatcher's questions were tailored to resolve that emergency. The dispatcher is focused on who are you with, where are you? There's a lot of discussion about the location and how can the police find this woman as quickly as possible. And most of the declarant's answers were geared towards helping to assist in the emergency. As Judge Lidge pointed out, to the extent any additional information was volunteered, that was ordered redacted from the phone call. And so anything that's arguably testimonial was removed from the audio and the transcript. And finally, this was far from a formal police interview. This is a woman who's in an informal environment, in a car with someone who's, again, brandishing a loaded weapon at her and is clearly not safe. So we would argue that each of the Kaju factors is met, that the district court properly determined that this was non-testimonial. And in that case, the law is also quite clear that the confrontation clause simply does not apply. My colleague has suggested that there's some additional confrontation right beyond the Sixth Amendment, but that's just not what the Supreme Court or this court's law shows. I think there's been a bit of progression from Crawford.
Ms. Lopez, could you just explain how did the redaction part come about? Because the argument you're making about the emergency nature of it, I'm just a little puzzled why parts of that call then would be redacted.
I know, Your Honor, that Judge Hornby, I believe, at a pre-hearing conference had raised concerns about some aspects of the call that he said were hearsay within hearsay when the declarant was reporting what she had learned about the gun being stolen. So I don't even know that it necessarily was a concern that that was testimonial, but there were separate evidentiary concerns. And so what the government did prior to the hearing is provided a redacted version to the court and said, we will agree to remove anything that's hearsay within hearsay, and we will call the person whose gun was stolen to testify about the theft. So that
5
would
minutes remaining
through the 911 call. So I don't mean to concede that that was testimonial, but simply that to the extent there's any concern that she volunteered more than was necessary to resolve the emergency, that's been eliminated because anything about the theft of the gun was redacted from the call. And then again, just to return briefly to this idea that even though it's non-testimonial, the government still has to produce her as a witness. I think it was, after Crawford, the Supreme Court sort of further defined the confrontation right in Davis and then in Bryant and made very clear that when you're evaluating a claim like this, the confrontation right only applies if the statement is testimonial. Once it's non-testimonial, the question at that point is only whether there's a rule of evidence that would allow the admission of the statement. So we would argue that that is the position that we are in here, that this was a non-testimonial statement, and then the district court set forth several valid bases under the hearsay rule for the admission of this 911 call. Unless there are additional questions from the court, we would rest in our brief and urge the court to affirm.
Oh, thank you.
Thank you.
Attorney Lopez, you can mute your device, and Attorney Andrews, if you could please present rebuttal.
I would like to address the assertion that nothing diminished the urgency of that emergency. When he brandished the weapon, she said that she asked him to put it away, which he did. And if she's assessing the level of danger that she's in, I think that that's a significant factor. That he seemed to be paying attention to her, and while he showed her the weapon, he also followed her instructions with respect to putting it away. The other issue that I would like to address on rebuttal is the more than necessary part. The call is replete with assertions like that he was a felon, that he possessed the firearm, all of which are necessary to prove the elements of the charges that he was facing, particularly that he was a prohibited person and that he had possession. Those are quintessentially testimonial in nature, right? In fact, that's why the government was asserting that he didn't need, or they didn't need to put on the collar, because the call itself established the evidence that they would have otherwise used to prove Mr. Estes guilty. And that is significant. That is significant both under Clark and if we look at the concurrences and dissents in Davis and Bryant, we can see why. We can see why because the major concern of the Sixth Amendment right to confrontation is to make sure that we aren't using statements as a basis for evidence. This isn't a situation like Davis or Bryant. Let's not forget, in Bryant, the gentleman who was making the statements passed away. And in Davis, the problem was that she didn't want to.
The one concern with your argument, just how could you give detail in a 911 call and not have it be just testimonial? Is there some way?
Well, I think that if you called and said, I have an emergency, and
but you couldn't say what it was, you couldn't describe it, like the emergency consists of a man with a gun who's threatening to kill me, that would be testimonial on your account,
well,
right?
I think it would be testimonial, particularly if you weren't using the declarant to come in and say that, right? There's a difference between having someone subject to cross-examination and someone who just comes and says these things or is unavailable. Thank you.
Further questions from the panel? No. Thank you, Mr. Andrews.
That concludes argument in this case. Attorney The next case today is Jessica Fagre versus Jeffrey Parks, appeal number 20-1343. Attorney Tavares.
Yes, thank you, Your Honors. Good morning. I would asked at the start to reserve 1 minute for rebuttal time.
Yes, you may have it.
Thank you. My name's Hunter Tavares. I'm representing the appellant Jessica Fagre in this matter, and we're respectfully requesting that you reverse the lower court's decision granting summary judgment because Amber Fagre, the deceased, was seized by Trooper Parks when he shot and killed her as she was a passenger inside of a SUV that Trooper Parks was intentionally firing at in an attempt to stop the driver and the truck, the SUV. Trooper Parks' conduct in firing at the SUV and the driver is not shielded by qualified immunity, and the result that ultimately led to Miss Fagre's death, because Trooper Parks at the time was on a 4-foot-high snowbank in a position of safety with an unoccupied police cruiser blocking the escape of the SUV on the narrow dirt roadway. Now, I would turn first to the issue, Your Honors, of whether there's a Fourth Amendment seizure here. And I understand there's a case from 30 years ago in this circuit, the Lando Rivera case, that suggests these facts would not support a seizure under the Fourth Amendment. But that case law, I respectfully submit, is dated and no longer good case law, particularly in light of the Supreme Court's case in Brendan, which clearly held that what's important is the intent to seize the driver or the vehicle, and that in intentionally doing that, any passengers are also seized as a matter of the.
Can I ask a question? So in Brendan versus in Landau, it seemed like, I mean, the police officer knew that there were two people there, and there was some intentionality about the fact that he seized the car with the two passengers in it. That's missing in these cases. It concerns me trying to hold the police officer accountable for a seizure that he couldn't have known he was making.
Well, Your Honor, I suggest the record would show that the officer reasonably should have known that he was making a seizure of Amber, the passenger, as well. The record demonstrates that he had information beforehand that she was a passenger inside the vehicle. He had no information that she was ever removed from the vehicle. While the officer says he did not see her in the vehicle at the time he was firing the shots, the record indicates that she was in the passenger compartment when she was shot and killed.
But quite a bit of time had passed between when he understood her to be in the passenger seat and when the shooting actually took place.
Approximately 17 minutes had passed, and when the officer returned to that same location where he had seen her before in the cruiser, he had no information at that time to suggest that she had been moved. And at least I think there's a factual question as well.
Except he didn't see her. Right?
I think there's a factual question.
The car comes barreling at him. He's trying to stop it. He does not see that there is a passenger in the car. He sees that this car is coming toward him. So why does that make this a Brendan situation?
Well, and whether the officer saw or did not see a passenger in the vehicle, when stopping the vehicle, all passengers are thereby seized, whether the officer was aware there was passengers or not. Brendan doesn't limit its
5 minutes remaining.
Thank you. Brendan doesn't limit its holding, Your Honors, to a situation where the officer makes a traffic stop, for example, and knows that there's a passenger in the vehicle. By making a traffic stop, by conducting a roadblock, by firing into the vehicle is seized and all occupants are seized. That's what Brendan, my reading of Brendan. Heading back.
Before we get to that point, I'm still confused. You're making an argument that a reasonable juror could find that the officer did see her?
Yes, Your Honor, absolutely. Based on the evidence that I've already discussed and the record shows.
What are we supposed to do in this case if a reasonable juror, if we concluded that the evidence was such that a reasonable juror could conclude that he wasn't credible in saying he didn't see her, and that given all of the circumstances about where she was, et cetera, that a juror could find that they just don't believe his testimony and they think he did see her. What happens in the case then?
I think the case, then the decision's reversed and the case is remanded for a trial on those.
Why, counsel?
Okay.
Why wouldn't he get qualified immunity? Because the question then becomes, from his point of view, can we say no reasonable officer could possibly have not seen she was in the car?
I think the question at that point, Your Honor, though, is whether no reasonable officer would have fired the shots into the vehicle, knowing that she was in the vehicle, or should have known that she was in the vehicle. And all the case law indicates that it's only when there's an immediate threat that the officer is justified in using deadly force. And at least there's a factual question here as to whether the officer was in immediate danger when he's on top of a 4-foot snowbank.
Well, with respect to there would be a qualified immunity issue as to whether a reasonable officer could have been worried about the imminent danger he posed upon getting out of the car. I guess my question is, if we thought there was a factual question as to whether he also knew she was in the car, how does that affect the reasonableness of his decision to use deadly force against the driver?
If there's a factual question on that issue, then it makes his use of force even more unreasonable, in that he...
I guess I'm wondering, was there argument about that? I mean, I don't quite see that in the case. In other words, to me, I could see the point that if a juror could find that he knew two people were in the car, then it's more like a Brentlin case, and then arguably that was clear at the time he should have known it was a seizure. Then there's the question of would it have been reasonable to use force? Well, we might think, it might have been reasonable to use force or to be worried that he would pose an imminent danger given all he had done and the shots that had been fired and the fact that he's barreling right at them. And if he comes out of the car with a gun, what happens, even though he's on the snowbank? My question is, does that calculus change? Or what supports the idea it changes from a qualified immunity perspective if he knows that Amber Fagre's in the car? How does that change it? And what case law are you relying on to suggest that that would change it?
Well, ultimately, Your Honor, our position is that it doesn't matter if he...
I'm asking if it does matter.
Right. How it would change the analysis is that it would make the officer's decision to use deadly force against the vehicle even more unreasonable.
What are you relying on to suggest that if he knew she was in the car, what he knows about her is that she was suspected of also doing these house break-ins with him at the time. So I guess I'm just wondering why, from a qualified immunity perspective, it's not as if it's a child in the back seat. So, but it is also somebody that he's saying is not the person he was aiming at. I guess I'm just, what case law helps me figure out about the reasonableness of using force if he knows that two people are in the car rather than just the driver? From a qualified immunity perspective, I didn't see anything in your briefing that really addresses that part of the case.
And I'm not sure if there is a case that directly addresses that, Your Honor. I think the case law that's relevant, though, is the case law that talks about a fleeing vehicle itself is not per se a green light to use deadly force. And the facts of this case are quite different than the factual cases where the court has upheld qualified immunity for firing at a fleeing vehicle. And all those cases that are cited in the briefs, the officers were an immediate
That's
risk.
time.
If I could finish the response just quickly.
Yes, go ahead.
Thank you. In all those cases, the officers were an immediate risk of being run over by the vehicle because there was nothing protecting them from that. This situation's different. We have the snowbank, we have the cruiser, and ultimately, whether he knew Miss Fagre was in the car or not, it really doesn't change the analysis.
Okay. Thank you.
Thank you.
Attorney Tavares, you may mute your device at this time. And Attorney Bolton, you may proceed.
May it please the court. Ms. Fagre's death was an accident. It was a tragic accident, to be sure, but it was an accident. The undisputed facts in the summary judgment record show that she was hit by a bullet that was aimed at and intended for her extremely dangerous companion, a person who was armed with a gun, who was driving an SUV towards Trooper Parks at maximum acceleration, whom Trooper Parks knew to have held a nearby resident at gunpoint in his home, and whom Trooper Parks reasonably believed to have just seconds earlier been involved in a gunfight with the other officers on the scene. I'd like to address the issue of his knowledge of whether she was in the vehicle, because I think the summary judgment record is very clear, and I think it's even a little bit stronger than was discussed previously, which is that it wasn't just that he couldn't see her in the vehicle, it was that he could see into the vehicle. He could see the passenger seat and the driver's seat. He saw somebody in the driver, and he saw that the passenger seat appeared to be empty. And the reason for that, we know because of the state's forensic expert, was because Miss Fagre was not sitting upright in the seat. And we know that from a variety of forensic facts that were and conclusions that were made during the investigation. So he not only couldn't see her, he thought he could. He would have thought that he was seeing whoever was in the vehicle because he could see the passenger seat. So it's very clear, and I think that overcomes, any knowledge that he might have had that much earlier in the incident that there was somebody in the passenger seat of that vehicle. The other point with regard to that is that, and
you think a juror could not reasonably find that, notwithstanding his testimony, he would have seen her?
I'm not sure I follow the question here. I'm sorry.
Well, I know there's testimony from him from the officer that he doesn't see her.
Correct.
Okay. There can't be testimony from anybody in the car about the likelihood that he did see them because they're both dead. Okay. Correct. But there is circumstantial evidence which suggests that she was in the car at the time of the approach. And I guess I'm saying your position is that it would be unreasonable as a matter of law if a jury found that he did see her, notwithstanding his testimony. Is that what you're saying?
I understand. Yeah, that is our position. And the reason for that, Your Honor, is the only testimony in the record is the testimony of Trooper Parks that he could see the seat and there appeared to be nobody in it. And I would add that you don't have to take his word for it because there is the forensic evidence which shows that she wasn't sitting upright, or is extremely unlikely that she was sitting upright. And just to be clear, there's actually two separate pieces of evidence that show that. There is the fact of the location of the bullet holes in the car and the entry and exit wounds show that. And also there is the fact that another officer fired a shot into the car from the other side that would have gone right through, went right through the space where a passenger would be, were they sitting straight up in the car. So there's really overwhelming evidence that she was leaning over, slumped over, something that she was not visible at the time as this vehicle was barreling towards Trooper Parks. So given that, and given that,
just to get the lay of the land prior to the car approaching the snowbank.
You say the other shot you're talking about that came from the other side?
No. I'm trying to get a sense of the basis if a juror were to find that he would have seen her in the car or known that she was in the car, even if he didn't see her in the car. I'm just trying to get a sense of what the lay of the land was prior to the car approaching the snowbank, to get a sense of what a juror could attribute as terms of knowledge of the officer. So she had never seen the car at any point, is that right?
I'm sorry, I missed the last thing you said there, Your Honor. I'm sorry.
Nothing in the record to suggest that she ever left the car, is that right?
That's correct. There's nothing in the record to suggest that she left the car. Yes.
And when does he, prior to the car approaching the officer here at the snowbank, what's the last thing he knows about the state of things before that car takes off? Does he see him get into the car? He
sees movement. Maybe I should just to back up a little bit. He sees her in the car 17 minutes earlier when he first arrives at the scene. He leaves the scene to go check on residents. He comes back. He sees a very different. He hears gunshots. He sees a very different scene where all the vehicles are now gone except for the SUV. He sees movement that he can't really distinguish. He sees somebody crouched behind a snowbank, and he hears gunshots. So he hears what he infers to be a gunfight. He never sees her in the vehicle, and because all the other vehicles are gone, I think it's reasonable for him to have thought that perhaps she was taken away in one of those vehicles. But then that's the fact that he can reasonably think that she's not in the vehicle is confirmed when it then the vehicle pulls out of the parking area, turns towards him, accelerates at maximum acceleration. He looks through the windshield and sees an empty passenger seat. So I think you put that together, and you have. I don't think any reasonable jury could reach the conclusion that he could see her. And in fact, we put that in the summary, our statement of material facts, that he did not see her at any point between when he returned to the scene and when the incident was over. And the plaintiff admitted to that fact. So that's an undisputed fact that was admitted. That's paragraph 86 of the statement of material facts. So I don't think there is any jury question about that at all, Your Honor. And under this court's decision in Landau Rivera, I think the fact that it's clear that the intent of Trooper Parks, objectively manifested intent of Trooper Parks, was to target specifically the armed and extremely dangerous driver of the Durango. That under that decision, this is not a seizure under the Fourth Amendment. It does not implicate the Fourth Amendment. It was an accident, and it was not the intent of the officer, as objectively manifested, to harm the passenger in any way. The Brenlin decision that the plaintiff discusses, that does not require this court to overrule its longstanding decision in Landau Rivera. That decision is the culmination of
we don't have to get to that question in theory, right? If we conclude that the officer, particularly if the only person he thought was in the car was the driver, if we conclude that at least under qualified immunity, he reasonably could have thought he would be in imminent danger from that driver, even if the car crashed, right?
That's absolutely right, Your Honor. I think you can look at the seizure issue, look at this through the seizure issue, and whether there was a seizure, you can look at it through whether the force was reasonable or not. And I think you're absolutely right. The question of reasonableness, because he didn't know she was in the vehicle, it would just be a pure question of was it reasonable to use deadly force against Mr. Bailey. That would be the only thing the court would have to decide here. And I think the evidence is overwhelming that would be a reasonable use of force. And I think that's this court's decision in the McGrath case is directly on point. I think the situation here was quite a bit more dangerous than in McGrath.
Can you explain to me just to make sure I understand the facts of this one last factual point,
Sure.
Which is, I know your opponent characterized it as a fleeing vehicle or an escaping vehicle, but if I understand the circumstance, am I right that what was appeared to happen would be that the Durango might crash and not be able to leave the scene? To me, that might bear on how reasonable it would be to using force because of the risk that he would then get out and use it directly against him.
That's correct, Your Honor. So the way this unfolds is Trooper Parks is originally taking cover behind the rear of his cruiser, which is pointed towards the Durango. As it becomes clear the Durango is going to ram the front of his cruiser, he moves quickly to his left onto the side of the road. As the Durango is colliding or about to collide with the Durango, he shoots 6 to 7 shots. The Durango pushes the vehicle back about 50 feet. The cruiser turns sort of sideways. You can see it in some of the photos in the summary judgment record, and it gets wedged into a snowbank. And at that point, the engine of the Durango is revving, but it can't go any further because the cruiser has essentially, because it's gotten wedged into the snowbank, is preventing it from being pushed any further backwards. So at that point, the driver is trapped, and deadly force, not by my client, but deadly force was used against the driver as a result after he refused to comply with police commands and appeared to be reaching for a weapon inside the vehicle. So it was a situation where he was cornered.
Your brother seems to argue that hiding behind a snowbank is adequate, regardless of the fact that the cruiser was there. What do you say to that argument?
Well, Your Honor, first, just one clarification. I know the district court described it as hiding behind a snowbank. What he actually did was climb on top of a snowbank. So he wasn't actually behind the snowbank. He was on top of it. And I think my response to that is the record shows, and it's undisputed, that the vehicles, when the Durango crashed into the cruiser and pushed it backwards, and both vehicles go by him, they pass within 2 to 3 feet of where he's standing on that snowbank. So I would submit that is way too close to say that he's in a position of safety at that point. If the collision causes the cruiser to jackknife or something like that, it could push it into the snowbank. If the Durango veers, if the driver decides that he's going to try and go around the Durango and he veers into the snowbank, that snowbank's not going to protect the trooper at all. So I would submit that is a threat of serious bodily injury in the moment he's firing those shots.
The threat is from the threat posed by the car while it's driving to him at the time he shoots. That's where you think the threat is.
I think that's part of the threat. The other threat is the fact that Mr. Bailey was armed. He had just been involved, or the trooper reasonably inferred that he had just been involved in a gunfight with the other officers. So as the district court held, it was reasonable for Trooper Parks to be afraid that Mr. Bailey would attempt to shoot him either as he was approaching or going by, or after, as you mentioned, he becomes, cornered essentially and gets out of the car and potentially there's a second gunfight.
Okay.
Thank you, Your Honors.
Thank you.
Thank you, Mr. Bolton. You can mute your device at this time. Mr. Zavaris has 1 minute of rebuttal.
Thank you again, Your Honors. I just want to address briefly the factual issue about whether a juror could find that the trooper knew that Amber was in the passenger seat. Moments before this shot happened, or these shots happened, Chief Brown, who was right there on the scene, saw Amber in the passenger seat. The trooper says he saw an empty passenger seat. He doesn't say he didn't see anyone in it. He said he saw an empty passenger seat. Seconds later, when the vehicle crashes, she's sitting in the passenger compartment. So whether I think it would be up to a jury to decide whether when he looked in there, if he did not see what was in there seconds later when the vehicle came to a stop. And I also thought about the qualified immunity analysis and whether the officer did actually know that Amber was in the vehicle. And I think it does change it, because if he is using force that seized her by killing her when she is not the threat, that absolutely would be a Fourth Amendment violation and not protected by qualified immunity. There was no information that she ever was involved in a gunfight, had a gun. She was not driving the vehicle. And even if he didn't intend to shoot her and he was aiming at the passenger
That's time.
If I just finished the thought.
Yes, go ahead.
By shooting and seizing her, even if it wasn't intentional, that's what Brenlin talks about, that it's still nonetheless a seizure. Thank you, Your Honor.
Thank you. Thank you.
That concludes the argument in this matter. Attorney.
May it please the court. My name is Danielle
I'm
Quinlan.
sorry. 1 second while I put us on the record. I apologize. The next case today is Matthew J. White versus Hewlett Packard Enterprise Company, appeal number 191696. Attorney Quinlan.
Thank you. May it please the court. My name is Danielle Quinlan, and I am here today representing Matthew White, the appellant in this case. May I reserve 3 minutes for a rebuttal?
Yes.
So the appellant respectfully asks this court to reverse the district court's decision and hold that HP's vacation pay forfeiture policy violates 26 MRS section 626, and that the district court erred in finding in favor of the defendant on the quantum merit and unjust enrichment claim based on the finding that some sort of contract existed. The first issue that I'd like to address is this clawback provision for HP's vacation pay. And then next I'll get to the company's deliberately confusing bonus plan and how that was dealt with. So 26 MRS 626, the pertinent part of this statute provides that whenever the terms of employment include provisions for paid vacations, vacation pay on cessation of employment shall have the same status as wages earned. And here we have a policy where Matthew White, the appellant, earned 120 hours of vacation pay at the very start of the year. He was entitled to 120 hours to use it how he saw fit. At the time that he left employment in that year, he still had 88 hours of accrued vacation time left. And, the court dismissed this theory because of some prior case law under Rowell and Richardson. And it's really important that we understand the holding in Rowell and Richardson, and how those facts really differ from the facts here. In Rowell, it dealt with a number of employees who were not automatically entitled to the vacation pay that they were claiming. They sort of had to, incrementally accrue that benefit. So it wasn't something that they were entitled to use right away. If they requested vacation time and they didn't have it accrued, that vacation time would be denied. So, they were seeking more than they were entitled to at the time that they left employment. So that's really a significant distinction here, because I think the language that was used in Rowell, and in this case from Rowell, was that entitlement to payment is governed solely by the terms of the employment. Once you're entitled, you are owed that vacation pay. So, that's one way to distinguish this case. And then again, in Richardson, this was another case that the lower court relied upon.
Explain how you're entitled, how you understand the word entitled, because
I'm sorry, what was that?
is my audio coming?
You're breaking up a little bit.
Can you hear me now?
The question was, could you explain the theory that your client was entitled to this, especially in light of the company policy?
Absolutely. So, every company has their own policy as to when you are entitled to take vacation pay. This company did not qualify entitlement to his vacation pay at any rate. So I think they had separate entitlement for salaried employees as opposed to hourly employees. Their hourly employees, it sounds like were.
Can you hear me now? Am I still breaking up?
Go ahead.
I guess the glaring question is, isn't there a qualification in the company policy? The qualification being that if you leave and haven't used it, you lose it. Why is that not a qualification like any other qualification? Because
this statute specifically prohibits that. Once you are entitled to the vacation pay, that vacation pay has the same status as wages earned and owed. And, there's a difference between the statute here and whether or not it's regulating, how you accrue something or whether you're able to roll over something. But they're saying once you earn it, it's yours and it needs to be paid out. So
Counsel, I'm now confused. You're saying it doesn't matter what the company policy is because he has an absolute right under the statute. Is that the argument? I had thought your argument was that the company policy is ambiguous, and as to that ambiguity, that means he has the entitlement. So which is it?
it is ambiguous, mostly because it provides an exception.
No, which of the two theories is it?
Well, I think it's a little bit of both. I mean, I can't really choose either because I think that the policy is a bit ambiguous as to, you know, they pick and choose employees that they do pay out these vacation.
Okay, then the first proposition has to be wrong because if there is an unambiguous policy that he is not entitled to it, then there is no statutory right under Maine law, correct?
Well, the difference here is that there is no ambiguity as to whether or not he was entitled to this vacation pay, and that's really the issue. The issue is
what you're if I understand, you're saying basically you're taking the position the Nebraska Supreme Court took with a similar statute. So your view is the word entitled in the statute.
Right. So the word
separate from a clawback provision. Essentially, it ousts the clawback provision. So once the company says that you are entitled to use it at your discretion, at that moment, it's locked in for purposes of the statute. And any provision of a company policy that would say they can then take it back upon your leaving is just inconsistent with the policy. Whereas a carryover or a future earning type thing, the entitlement never kicks in because it's never vested, even under the policy itself. That's the idea.
Exactly. Very, very well worded. That's exactly what I'm trying to say here.
Maine's never ruled on that question one way.
Exactly, which is why Richardson and Rowell really don't apply here because it's just a completely separate issue. And I think using the reasoning from the lower court, he just kind of, he missed the point here that this is a completely separate employment situation.
That's time.
Do you know if any states with similar statutes have held that those statutes don't prohibit clawback provisions? I know you cite some that do prohibit clawback provisions. Is there any state court that has allowed a clawback provision?
I'm not aware of that because I wasn't specifically looking for that issue. I'm sorry, did you say it was time or was it not?
Yes, it's time. Thank you. You have your rebuttal time reserved. Okay.
Thank you.
Attorney Quinlan, you can mute your device at this time. Attorney Caterin, if you could please unmute your device. And you may proceed.
Good morning. May it please the court. My name is Melinda Caterin, and I am here on behalf of the appellee Hewlett Packard Enterprise. This appeal involves two express written policies which defeat White's claims for vacation pay and bonus compensation. As the district court concluded, there are no genuine disputes about these dispositive facts, and as a result, summary judgment was properly granted. HP's vacation policy provides in relevant part, employees are strongly encouraged to use all of their vacation each year. If you leave HP for any reason, either voluntarily or involuntarily, you will not receive pay in lieu of unused vacation. All unused vacation will be forfeited at the time of your separation. Here it is undisputed.
Caterin, would it be fair to say that prior to his leaving, he was entitled to use the pay that's being taken away?
He could have used his vacation time, and if he had.
Why wouldn't it be plausible to say that he was entitled to use it under the contract prior to him leaving?
Because the employment, because the policy specifically provides that if you don't use it during your employment, it will not be paid out upon termination. And the Maine law court has repeatedly said that that is appropriate.
I understand it. Just bear with me.
Okay. Sure.
Would he have been entitled to use it before he left?
He could have used his vacation.
I know you say he could have, but he would have been entitled to use it, wouldn't he, before he left?
before he left, and he voluntarily resigned, so he could have used his vacation before he left. He had that option.
Yeah. He was entitled to do that, right?
He was entitled to use his vacation prior to his resignation.
And that's not true of the plaintiffs in either of the main law court cases. The vacation,
well, that's not so.
They were not entitled to use before they left.
That's not so. In fact, it appears that in both of those cases that they could have used them, and especially in Richardson, he had accrued 178 hours of vacation, and he could have taken it.
At the time the case arose, he was not entitled under the contract to use the vacation time he was seeking to use prior to leaving, because he had already forfeited that because it was carryover time, right?
That's not correct. In Richardson, he could have used the time, but the provision in the contract said that he would only be paid out 30 hours of that upon termination. So it was, in fact, it acted as a forfeiture. And in Rowell versus Jones and Vining, they specifically address the issue that is presented here. It says, we next turn to the plaintiff's second argument that because earned vacation pay has the status of wages rather than a gratuity, the vacation plan cannot be interpreted to divest plaintiffs of earned vacation benefits. We disagree. So they address that specific issue.
Is there any state you're aware of that's upheld a clawback provision under a statute like this? I know Nebraska has not. Is there any state that with a similar statute to 626 has said a clawback provision is consistent with such a statute?
I'm not certain of that, but there are only 4 states that I'm aware of that say that you're required to pay the accrued but unused vacation out upon termination of employment. And Maine is not one of those states. The Maine Law Court and the Department of Labor have repeatedly said that, and that's been the law for over 30 years. So the law court cases and the federal district court cases from the state of Maine have repeatedly said that. Snow versus Borden.
The question is whether a clawback provision presents just a different question. And the thing that's somewhat concerning, particularly, is like in the Nebraska case, where it arises out of a termination rather than a departure. Because the risk, you can see what the evident risk is, which is that you have earned a bunch of pay, you're entitled to use it, they now see you have all this pay accrued, and they fire you, and then you lose all that earned time. And under your account, the Maine Law Court would say that's fine.
Correct.
And there's a reason to be somewhat concerned about reading this statute to have sanctioned that when neither of the Maine Law Court cases address that circumstance.
Although the federal district court has in Snow versus Borden, they did address that precise issue. But what I would also say is that the purpose of vacation is for rest and relaxation. It's not to be a termination bonus, if you will. It's designed for people to take time off to re-energize and to come back to work and be more productive. It's not meant to be some type of a bonus. So it's there for people to use during their employment. 5 minutes. And so for that reason, I would also argue against having to certify the question to the law court, because I think it's a question that has absolutely been decided on multiple occasions by the law court. And I'll move on to the next argument regarding the bonus. In White's complaint, he alleges that he's owed a $10,000 Cisco market share bonus for the last quarter of 2014. And the district court properly concluded that the bonus program was governed by its written terms and had a program end date of October 31st of 2014. Construing the record in the light most favorable to White, who would argue that the bonus program was non-discretionary, the district court found that a contract existed. The district court also noted that both parties have proceeded on the premise that the written terms of the market share bonus program were binding. As a result, the district court correctly concluded that White's unjust enrichment and quantum merit claims were barred by the contract. In addition, on summary judgment, HP argued that the parties shared a contractual employment relationship, including sales incentive compensation, and that the undisputed written terms of the market share bonus program ended on a specified date of October 31, 2014. HP further argued that the plain language of the market share bonus precludes payment. In his opposition, White completely failed to respond to HP's argument regarding the expiration of the bonus program and therefore waived any challenge to that argument. This failure alone was grounds for the dismissal of White's bonus claim. And regardless of whether the market share bonus is construed as a contract, White has failed to present evidence that could establish his entitlement to additional payment under theories of quantum merit or unjust enrichment. White does not present any evidence that he performed any service or conferred any benefit on HP beyond what was already expected of him and what he was fully compensated to do. In addition, White has not demonstrated a reasonable expectation of additional compensation. White's only source of expectation for the bonus came from the written bonus program offered by HP. That written bonus program clearly and indisputably ended on October 31st of 2014. White simply contends that he was confused by the operation of HP's bonus program. White's confusion cannot support a claim that he had a reasonable expectation of bonus compensation for the Cisco market share bonus during the last calendar quarter of 2014. Finally, White cannot demonstrate that HP had a concurrent intention to compensate White for his alleged services related to the reduction in Cisco's market share, nor did HP appreciate the benefit of the claim service. To the contrary, HP indisputably chose to end the market share bonus on October 31 of 2014. HP's actions transparently communicated that it no longer considered changes in the Cisco market share as a benefit that it would appreciate. And I'd be happy to respond to any questions that you have.
Oh, thank you. Okay, thank you very much. We'll hear the 3 minutes of rebuttal.
Thank you. And Your Honor, may it please the court, I'd like to just briefly go back to the vacation pay issue and just really highlight the fact that the accrual section of the personnel file, to the extent that, we're looking at how the vacation pay was accrued, that was a completely separate section of the personnel policies from the forfeiture policy. It was completely separate. So you accrue over here, you forfeit down here, and I think we can just separate the two. And once accrued, it cannot be forfeited under this clawback.
That was true, at least in the main retirement case also.
The main retirement case, that was a year-to-year contract. So he only had that principal had a contract for 1 year. He was only entitled to employment for 1 year, and it was renewed year to year. So it's a completely separate situation from this one.
Well, why does that follow?
Because this was an employee at will, and each year he continued his employment based on different employment expectations,
okay.
As opposed to the clear
your next point.
My next point, going to this this quantum merit unjust enrichment theory based on the bonus program, it was an extremely confusing bonus program. And we're really looking at everything after October 2014, because after that is when we get into the issue where the management are so confused by the bonus program and the terms of it that they tell their team they're still eligible for this bonus, and the team meets those expectations. Unbeknowingly, they canceled the program, and nobody communicated that to the team until they came with the expectation of payment, and that payment wasn't there. And, Judge Hornby really glossed over a significant record, which led to the confusion. You have this management team at Hewlett Packard who says, we need to change this plan. It's tedious. We require additional action. It will not follow systematically. It will affect who will be paid. There's emotion, hand-wringing. absolutely unclear terms. There's emails that cite bonuses not being paid, confusion in the calendar between fiscal year and calendar year. And the company should not be rewarded for having such a confusing bonus program that not only do their employees not understand what the terms of it are and what they're entitled to, the management and those executing and paying out the bonus plan don't understand the terms of it and are conflictually communicating to their employees that there is an expectation to be paid under this plan if they meet certain metrics.
I want to just go back to the retirement point. Could you just help me? You explain what the difference between these two things is? If I understand your account of the retirement plan case, or the retirement case that was before the main law court, you said it was an annual contract. And so the idea that the contract provided that you would lose the vacation time you accrued at the end of the contract, correct?
I think it dealt with a rollover. So, you know, from year to year, it allowed a rollover of certain vacation pay. But if you were to retire and not renew your contract, you were only going to get 30 hours for that year.
Could you explain how that's different than this situation where they say you're entitled to it, but if you leave, you lose it? What's the difference between that and you're entitled to it, and if your contract ends, you only get 30 hours of it? I don't really understand the difference between those two things.
Because if you look at what he was entitled to in that same year, it was significantly different than what he was claiming he was entitled to overall. So if you look at, and I'm not sure exactly what the hours were, I think it was 180 hours he thought he was entitled to. A significant number of those hours had rolled over from previous years. And was
any hour over 30, as I read the main law court, they would say he couldn't get, even though he was entitled to it in that year. So how is that different than your situation? Because that seems just like a forfeiture provision like this one.
Well, if you look at what he was entitled to for that year's contract, he was not entitled to 180 years in that 180 hours in that year. Those were previous hours that he had earned in separate years under separate contracts. But if you look under that 1 year's contract, he had something like 80 hours, and you know, he had used other hours from other years. So it's a different employment situation. It's a different employment agreement.
Anything else?
No, Your Honor.
Okay.
Unless you have questions.
Thank you. Thank you all. We're going to take a break for 3 minutes. I'll let the clerk announce it.
Thank you. That concludes the argument in this case. Attorney Quinlan Next case today is NCTA, the Internet and Television Association versus Aaron M. Frey, appeal number 20-1431. Attorney Amundson.
Good morning, Your Honor. Jessica Ring Amundson for appellant NCTA. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
Yes.
Thank you. May it please the court. The Federal Cable Act establishes a national framework for cable regulation that defines and limits the role of states and localities. The Cable Act provides the permissible metes and bounds for regulation of both PEG channels and build-out requirements. And Congress was unmistakably clear that it intended to preempt any state or local regulation inconsistent with those limits. Maine's Act to ensure non-discriminatory treatment of PEG channels ignores those limits and attempts to place PEG on equal footing with broadcast channels under the guise of consumer protection. Maine's Act likewise ignores that build-out requirements cannot be imposed outside of the franchising process with no consideration of whether they're reasonable to meet community needs in light of costs.
May I ask a question, please? I understand, I'd like to draw a distinction between the line extension and the 3 PEG requirements, 3 categories of PEG requirements. I understand the parties have stipulated that the PEG extension only applies upon the renewal of a franchise or there being a new franchise. Is that correct?
That the line extension requirement applies only to renewals. Yes, Your Honor.
Okay. Now, as to the 3 categories of PEG requirements, they are not dependent on there being a new franchise agreement. They are intended to be effective immediately. Is that correct,
Your Honor?
Okay. So the district court, in its opinion, cites to a House report that basically says states are not free to impose new conditions on existing franchise agreements unless there are unless they are consumer regulations. Okay, so the district court said these are all consumer regulations. If they are not consumer regulations, does that mean that while the state might or may not be able to do this prospectively as to new renewal agreements, it cannot do that as to the existing agreements? From looking at the record, it appears to me that none of the existing franchise agreements contain any of these 3 categories that the state now wishes to impose on local franchisors. Is that correct?
That is all correct, Your Honor.
Okay, so hypothetically, if we were to decide these were not consumer regulations, then in fact, it's preempted without getting into all of these specific preemption. It's essentially preempted because it's not prospective in its application. Are we left then with a ripe dispute as to prospective application? The way I read the record, the first renewal that is to come up is in 2022. Is that correct?
No, Your Honor, that's not correct. There are franchises that are subject to renewal right now.
Right now. Okay. So you would say as to those, there is a ripe controversy which would force us, even as to prospective regulation, to decide the type of preemption arguments. And I understand those to fall into sort of two categories. I'll get back to that in a minute. And that we must go ahead and resolve that.
Yes, I believe so, Your Honor, that because there are renewals pending now and because what Maine has done is attempt to essentially impose the PEG requirements on existing franchises, that we believe that should all be decided now under the proper preemption standard.
Okay, but it strikes me there are different categories of preemption, whether it applies to existing franchises and whether it applies to future franchises. Okay, so, and pardon my simple-minded approach to this, but as to the PEG regulations, I don't want to get into line extension. There seem to be sort of two buckets of arguments about preemption. First is the bucket of arguments that says the state can't, if the local franchisors are preempted from doing certain things, then the state can't. The district court disagreed with that, but let's assume hypothetically that's true. As I understand your argument, you are saying then it becomes a question under the term adequacy. If the local franchisors are being afforded adequate PEG services, then neither the state nor the local franchisors can impose additional requirements, both because of specific provision and because of the structure of the act. The district court rejected the notion that adequacy was the proper preemption standard. Then there is the second category of preemption claims that are tied separately as to each of the three to specific federal statutes about allocation of power between the FCC and local regulation, whether it be by state or individual franchises. Is this basic structural understanding correct?
So, Your Honor, I think you did sort of separate out the two flavors, but I do want to take Your Honor back to where you started, which was the district court's decision that states are not bound by the Act's limits on franchising authorities. And I think that the preemption standard that's set forth in 556C
4 minutes remaining
shows that that can't be the case, that what Congress intended was that no state law that is inconsistent with the federal framework.
Okay, but with deference, can't we move beyond that? If we assume that if a local franchisor cannot do something, then the state can't do it either. Just make that operative assumption. Okay,
yes.
So now we're getting into, well, what can the locals do as...
Yes, Your Honor, I agree completely with that. It's that the district court read it exactly the opposite and said that the state was not, even if the franchising authority wasn't allowed to do something, that the state was allowed to do something. But
okay, I appreciate that is a key decision that has to be made. But now can we get to the arguments, the other arguments about preemption?
Yes, Your Honor. And so did you want me to address the specific provisions of preemption?
Well, first, let's talk about adequacy.
Okay.
The district court rejected that as a standard. She said Gee, I just don't read the statute that way. You
Right.
say, no, that's an incorrect reading of the statute. So
Yes.
why?
Yes, Your Honor. So both Section 531, which sets forth what franchising authorities and by extension states are permitted to do with respect to PEG, and Section 541, which sets forth the adequacy standard that Your Honor was referring to, set the permissible limits of regulation. And so what the FCC has said is that what adequacy means in this context is satisfactory or sufficient. The district court held that Section 531 and Section 541 didn't even apply here. So it said the adequacy standard was completely off the table. It didn't even have to look at 531 and 541.
I believe Judge Barron has a question.
If you would like adequacy to be a preemptive provision, could you address the words that adequacy is modifying and why those words are implicated by the main regulations of the PEG channels? But I thought it's financial support, facilities, and capacity. Which is the word that is implicated by the PEG regulations by Maine in your view?
Well, Your Honor, what we're saying is that what Maine has done is not permitted at all by the statute. So it doesn't even, it doesn't go to add capacity, facilities, or support. So it's beyond anything.
No, that's the 531 argument. And I want to come back to that. If you're saying that the adequacy provision is a specific provision that leads to an inconsistency that results in preemption, we have to look at the text of that adequacy provision. And it says what has to be adequate is the facilities, capacity, or financial support. Which of those words is implicated by the main PEG requirements?
So, Your Honor, what I'm saying is that the main PEG requirements are wholly outside of what can actually be demanded. So it is neither capacity, facilities, or support.
Does that mean the adequacy provision is irrelevant to your preemption argument and that your locus of your preemption argument is elsewhere?
No, Your Honor. I mean, what we're saying is that the statute limits what franchising authorities and by extension states are permitted to do. It can require in 531 capacity, and then in 541 adequate capacity, facilities, and support. This is beyond any of those.
Okay, so you need a number that tells you that that's all you can do. And you're saying that provision is 531.
Right.
Okay, so going to 531, could you explain to me how the PEG requirements implicate a designation of channel capacity or a use of channel capacity?
They do not, Your Honor, and that is why we think that they are beyond the authority of the state to impose, because 531 tells the state what it is allowed to do, and it doesn't allow the state. So, Your Honor, if I can point you to 531.
531A says that they can regulate with respect to channel designation of channel capacity and use of channel capacity only to the extent provided in this provision. It does not say they can only regulate the designation of channel capacity or the use of channel capacity. Those are very different sentences. You're reading 531 as if it says you can only regulate designation of channel capacity or use of channel capacity, but the text says you can only regulate with respect to the designation or use to the extent that this provides. I don't see why that tells you that that's all you can do.
Well, Your Honor, I think if we just step back and see that what Congress was doing here is setting up a federal scheme, and it established on the one hand PEG channels. It has a separate provision, Section 534, about broadcast channels, and the provision about broadcast channels includes some of the things that Maine is looking for here. So the provision about broadcast channels has an entire section on channel placement. Congress chose not to put that in the PEG section, Section 531. So when you contrast 531 and 534, there's also in Section 534 a whole section on signal quality. That's not in 531. So
is the 534 channel placement provision an authorization to do that or a limitation on it?
It's a requirement about where channels have to be placed, about where broadcast channels have to be placed.
say that there is a prohibition against the exercise of authority, which is a very different thing to read 531 to prohibit that. And what I'm saying is that just reading the text of 531, it's written as you are allowed to do these things only to the extent as set forth below, not as you are only allowed to do these things, just as a textual matter.
Well, Your Honor, with respect, I think that all of the things that Maine is trying to do flow from designating capacity. They're trying to do things on top of what is required under the act. And if the court looks to the way this court applied the 556C preemption provision in Liberty Cablevision, what the court did is looked at the fact that Congress was establishing a national framework, a federal framework that delineated the roles of states and localities versus the feds.
One last time, if you don't, and you don't agree with how I'm suggesting 531's read, that's totally fine, and you've laid out really nicely in your brief why I'm wrong to read it that way. Assuming you're wrong, and that 531 itself is not textually providing the limitation, I had thought you were making an argument that the adequacy provision independently served as a limitation. And I'm just wondering if that's so, that would make sense to me if the PEG requirements implicated a regulation of facilities, capacity, or financial support. And I'm asking, is there one of those words you think it's implicating? I'm hearing you say no, but that doesn't matter because it's preempted anyway, which is fine, perfectly coherent argument. I just want to understand what you're saying to us.
So, Your Honor, we do argue that the adequacy is a limit on what you are allowed to do. And I think, as I said earlier, all of them—
No. You keep evading Judge Barron's questions. Let me try to get you to focus. What about the PEG regulations go to financial support, facilities, or capacity?
They flow from the designation of capacity. So once franchising authorities are allowed to require capacity, they're now imposing extra requirements on how that capacity must be provided. It must be provided in certain channel slots, at a certain resolution, and with certain sort of content in the electronic program guide.
Okay, skipping ahead a little, although I must say a logic professor would have fun trying to figure out the decision trees in this case. I view the guide as having a slightly different set of concerns than the other two, which is, as I understand, the state is arguing independently, even if it can't regulate the first two sets of PEG concerns. Nonetheless, it can regulate the third because you have not adequately provided information in your guide. Your response was, the guide isn't up to us. The franchisors need to deal with a third party, and we're not stopping them from doing that. But what's that strikes me as a bit of a mismatch. Even if you were permitted to make these changes without state regulation, how is it that people find these channels when you move them, you don't provide any specific information about where they can be moved? So could you address that?
Yes, Your Honor. So just to clarify, when they are moved, consumers are notified that they are moved and where they can find them.
How?
With respect to mailings and notices on their subscriber bills, Your Honor, and that's through an FCC.
Okay, why isn't that in the guide? Many consumers would look to the guide for that information.
Well, they can find PEG channels in the guide. They simply cannot find, in most instances, the hyper-localized programming, and that's because the PEG providers don't actually supply that. But if I could just take the court to the legal issue here, which is that the guides are an information service, and that states and localities are precluded from regulating information services under Section 544B1.
Okay, I'd like to, thanks. I'd like to step back. At a few points in the argument, you rely on FCC interpretations. You rely on the state can't do this on an FCC interpretation. I thought you were also relying on an FCC interpretation as to the scope of authority as to adequacy. So could you tell us exactly what issues you're relying for FCC interpretation on, and what deference you think we owe the FCC interpretations?
Sure, Your Honor. So, this is not, as you know, an agency deference case, but nonetheless, the agency is the authoritative body charged with interpreting the provisions of the Cable Act, and so we think that the FCC's interpretation should be given weight. And so, in terms of which FCC interpretations we're relying on, we're looking at the FCC that has interpreted HDTV as an advanced television requirement that would fall within the signal quality prohibition. And so, the Maine Act on its face regulates signal quality, and that of course the Federal Cable Act says that the state may not do that. So that's one of the provisions. Another provision where we're relying on the FCC is with respect to adequacy, as I said, where they define adequacy as satisfactory or sufficient. And then we're also relying on I know Your Honor wanted to set line extension to the side for now, but we're also relying on the FCC in saying that build-out requirements are subject to the standard under 546, that they must be justified as reasonable to meet community needs in light of costs. And so those are some of the areas where we're relying on the FCC.
Okay, so what's the issue on the line extension? Are you saying the state law precludes consideration?
Before you go to the line extension, just want to make sure we've hit all the many provisions, unfortunately, that we have to resolve in this case. So on the electronic programming guide, you say it's an information service. And if it is, then you say that is something that the local franchise authority can't do, which would then tee up the question, if we agreed with you, as to whether the state nonetheless could do it. We'd have to tackle that issue. But there's another provision, which is the prohibition against the regulation of cable service content or content of a cable service.
Provision or content, yes, Your Honor.
That provision, as I understand it, bars the state as much as it does a franchise authority.
That's correct, Your Honor.
That question. I understand you to be saying, at a minimum, the electronic channel guide is a cable service of which the content is being regulated definitionally, because they're telling you what content to show on the guide.
That's right.
Right?
Yes, Your Honor.
Do you have any authority? There's a DC Circuit case which talks about programming of a very different kind that is the content of a cable service. Do we have anything that is analogous to this? I mean, it is one step removed from the typical type of programming that you would regulate. And obviously Congress was interested in making sure these PEG channels were usable. And there is something a little bit askew about the notion that the Congress that was so intent on making sure the PEG channels were usable also wanted to preclude states and localities and franchise authorities from doing anything to make it knowable what was on the PEG channel to the viewer. So that is a little bit of a paradox. So it's not obvious to me that we should read content of cable service as broadly as you want to, but you have anything that would help me think through that?
So, Your Honor, I can't point the court to a case that says that regulation of content on electronic program guides is content for purposes of the provision in 544. And the court is correct, of course, that in United Video, the programming at issue was slightly different. But I do want to sort of address kind of the premise of Your Honor's question, which was that Congress wouldn't have wanted cable operators to make these PEG channels sort of non-findable or non-viewable. And I wanted to just sort of get at a large part of the state's argument is that cable operators are sort of doing something very nefarious and moving channels, et cetera. And what is happening is actually, as we have the affidavits show, is that PEG channels are moved and placed in sort of genre-based groupings. They're with PBS channels, and so
because we don't have much time, I understand. You said that in the brief, and I know that. So the other two issues on the PEG channels that I wanted to work through before we switch over to the line authority. On the signal quality, you referred to it as a provision that dealt with signal quality sort of in totality, but as I read it, it says minimum technical standards regarding signal quality. So there seems to be at least an interpretive question as to whether a requirement that the signal quality that is the programming is received in must be transmitted in that same signal quality to the extent that the franchised already has that capacity because it's doing it for other channels. It's not obvious to me that that is implicating the provision that talks about minimal technical standards for signal quality. Could you address that?
Sure, Your Honor. So I guess 3 points in response to that. First, the fact that it says minimum technical standards for signal quality, the Supreme Court was quite clear in the City of New York case that does not give states and localities the right to regulate sort of on top of those minimum technical standards.
Respect to technical standards, but the question here is this main requirement that you simply transmit the programming you get from the PEG in the same signal quality you receive it in if you're using that signal quality for broadcast channels? How is that a technical standard of signal quality at all, as opposed to just a regulation with respect to signal quality, which is a different phrase than is used in the Cable Act itself?
Yes, Your Honor. So I think on its face, what the Main Act refers to is signal quality. And if the court contrasts the provision at 531 with the provision at 534.
How is it a technical standard of signal quality?
Right. So it is requiring a particular standard format for transmission. And again, I want to point the court to, Maine wasn't shy about what it was doing here. It was trying to place PEG channels on an equal footing with broadcast channels. But that's not
counsel, you seem to be missing the thrust of the questions. If you're already providing high definition and regular, I've forgotten the term for it, and if the PEG channel is providing you with high definition, so you've already worked out signal quality issues. What's wrong with the state saying, if it comes to you in high definition, you ought to broadcast it in high definition?
If you can do it already, because you're doing it for other channels. It's not as if they lack HD quality capacity.
Well, Your Honor, on the facts with respect to PEG, they do in fact lack that, because there have to be, because of the transmission from the PEG facilities to the cable provider's head end, it would require actually significant upgrades of equipment in order to carry things in HD. So Your Honor,
whose equipment?
The cable operator's equipment.
All right. Judge Barron had a question.
So just so I understand, even if it's received in HD by the cable operator, and even if the cable operator otherwise is able to broadcast channels it receives in HD and send it out in HD, in order to send out PEG HD programming, it would require additional expense?
Yes, Your Honor, because of the way that it is transmitted from the PEG facility to the cable provider's head end. And that's why we're here, Your Honor, that it actually would be.
And that's there's evidence in the record of that point?
Yes, Your Honor. The affidavits that we submitted in the record below show that it would require significant upgrade of PEG, of equipment from the PEG facility to the cable operator's head end in order to provide HD. But the broader point is just that what the main act does on its face is regulate signal quality and try to incorporate the provisions from 534 into 531.
Last one I wanted to ask you about was I think it's 543.7b, or is it 534.7b, the one that's about the regulation of effective, whether there's effective competition, yes. Okay, and channel placement. One thing I'm just puzzled by on that, I understand your argument otherwise about why you say there's an implicitly preemption there, but the text of 543.7b, as I read it, I'm sorry, 543b7, just says each cable operator of a cable system shall provide its subscribers a specially available basic tier. And then it says on that basic tier there have to be PEG channels. The DC Circuit seems to have read that provision as if when it says each cable operator of a cable system is implicitly talking exclusively not about each cable of an operator of a cable system, but only about those operators of cable systems that are not subject to effective competition. And that seems to be a premise of your reading as well. Is that right?
I think that's right, Your Honor. I think, yes, that it's, it's undisputed that
where that's coming from, because just textually, I'm not seeing anything in the act that says that, and the text would seem to say that the basic tier for each cable operator of a cable system has to include the PEG channel, which seems quite the opposite of how you're thinking about it. But I take it the DC did read that as if it has this implicit limitation to those cable operators that are not subject to effective competition. But if you could, I just don't see anything in the text that is supporting that. Am I missing something?
Well, Your Honor, what Congress intended in the act was that once competition took effect, the whole system set forth in 543.
The way to figure out what they intended is just look at what they said. So is there anything that they said that supports this notion of their intention?
Well, it's 543b7, and then it's the provision that says that once cable operators are are subject to effective competition, they are no longer required to have basic tier carriage. So
it doesn't. Where does it say that? That
is, Your Honor, at 533A3, I believe, Your Honor. So once the cable operator is subject to
3A3.
Let me check, Your Honor, or I can certainly come back on rebuttal and point Your Honor to that provision. But the idea is that what Congress set forth was that was that once effective competition took hold, basic tier requirements were no longer in effect. And so what Maine is doing here is it is both requiring carriage on the basic tier, even though it's undisputed. I'm sorry, Your Honor.
I guess I see that with respect to rate regulation. I just didn't see the provision in the text that talks about it with respect to what's on the basic tier. So the only provision that speaks to that seems to specifically say each cable operator, which would be everybody. And that's why I'm just puzzled.
So basic tier carriage is a component of rate regulation, and that's the DC Circuit's opinion in Time Warner. So I don't know if the court wanted to turn to, I realize I'm way over time, but if the court wanted to turn to line extension at all, or
line extension if you want, Judge Lynch.
1 minute.
Thank you, Judge Lynch. With respect to the line extension requirement, we simply wanted to reiterate that The reason that it is facially invalid is because Maine is stepping into the shoes essentially of the franchising authority and dictating a substantive franchise provision of 15 homes per mile without, it's undisputed that there are no findings at all that it is in fact justified to meet community needs in light of costs. And so effectively, all of the existing franchises that as they come up for renewal will have to be denied unless they include this provision. And so that is why we think this provision is preempted on its face from the 546 renewal standard, because Maine has made no findings that it is justified in light of costs. And the FCC recently reiterated in its third report.
Okay, as to that, here are my questions. Suppose we think that the state of Maine is simply not precluded by the Cable Act from imposing regulations that require franchisors, the cities and towns, to comply with certain state requirements, so long as the franchisors are not themselves preempted from doing so. All right, your argument seems to be that in every single case that will come up in the future under these new line extension provisions, necessarily there will be no consideration of cost versus benefit. Whereas it's very hard for us to see now why that is necessarily the case. And that tends to suggest that there could be as applied challenges in the future as opposed to a facial invalidation right now.
Well, Your Honor, what I think Maine is trying to do here is to flip the burden. During the renewal process, it is the local franchising authority's responsibility to show that what they are requiring of the cable operator is justified to meet community needs in light of costs. And so just to play this out, as a renewal comes up, if a NCTA member in Maine says 15 homes per mile is not justified to meet community needs in light of costs, the the local franchising authority's answer is tough. That's what state law requires. So what the state law is mandatory. It does not say, for example, that state or local franchising authorities shall include a 15 homes per mile requirement so long as they show that it is justified to meet community needs in light of costs. I think if the provision said something like that, we wouldn't be here. Instead, it's a mandatory provision.
If that's your argument, and it's right, if it were right, wouldn't that independently be a basis for saying that all of the PEG requirements are also preempted?
Yes, Your Honor, we did make that argument that they're also independently preempted by the 546 renewal because there's been no finding that they're justified in light of cost. The district court completely sort of ignored all of that because it started from the premise that these were all consumer protection regulations, so it could impose them on existing franchises.
Slightly surprising feature of this argument is that all of these cases that I've read dealing with all these different regulations, like all the DC Circuit cases about the basic tier regulations, none of those state requirements seem to have this upfront reasonability constraint imposed on them. And yet, under your view, a lot of people have been wasting a lot of time going through these various provisions of the Cable Act to see if they're preempted. Because they could have looked at the face of it and seen, well, you didn't have a built-in upfront reasonableness limitation, therefore it's automatically preempted. And since that doesn't seem to be how anybody's been regulating these things or thinking about it, it's just a little surprising that hidden there all along was this prohibition against any upfront regulation by any franchise authority or state that didn't already have in it a requirement for them to show that it would be reasonable in application, rather than the idea that you could impose the regulation and then it would be subject to the reasonability determination at renewal.
Well, Your Honor, I think at least in this case, it's undisputed that there's nothing in the record that this is reasonable in light of costs. So I can't speak necessarily to the cases that Your Honor is looking
Yeah,
to
but there's nothing in the record that it's inherently unreasonable either.
Well, but Your Honor, that's precisely sort of why Congress channeled things through the franchising process, so that.
Okay, all right, we're going round in circles now. Thank you very much.
Thank you, Your Honor.
Attorney Ring Amundsen, you can mute your device at this time, and Attorney Taub, if you could unmute. You may proceed.
Good morning, may it please the court. Chris Taub for the appellees. I'd like to start with some of the questions that Judge Lynch was asking at the very beginning of the argument relating to the district court's reference to something in one of the Senate reports, or I guess it was the House report, about requiring certain provisions to be reflected in franchises. There's actually an ellipsis in the district court's decision, and she actually left out what I think is a pretty important phrase. So what in fact the report says, and this first phrase is the one that was left out in the district court's decision. It says, if under HR 4103 or any state law, a requirement imposed upon a cable operator must be reflected in a franchise, the state may exercise its authority over cable either by establishing a state franchising authority or by placing conditions on a local government's grant of a cable franchise. And then there's the language about how it has to be inserted when it comes up for renewal.
Mr. Taub, do us a favor, send us a letter afterwards giving us the precise language you want us to focus on. Okay?
Certainly, Your Honor. And just to close the thought, it's our point that the provisions at issue, the PEG provisions, aren't required to be reflected in a franchise. So I just wanted to make that note. I think it might make sense because these provisions were discussed a lot before, just to kind of dive into sections 531 and I suppose also 541, I think it is. So 531, and I think the appellant's argument has morphed a little bit during this oral argument. But when it came to 531, their brief, I think, is a little bit misleading in how they characterize 531A. So the way they characterize it, they say a franchising authority may establish, and then these brackets, PEG requirements, and then they have an ellipsis, only to the extent provided in this section. But I think, as Judge Barron was pointing out, what it actually says is a franchising authority may establish requirements with respect to the designation or use of channel capacity. I'm sorry?
Why are the main PEG requirements, in your view, not with respect to the designation and use?
Yeah, so our point is that the designation is how many PEG channels are you going to require, and what are they going to be designated for? Like, is one going to be designated for governmental use, one for educational use, and then the use of the capacity is sort of the use by a third party. Okay. But I think what's really significant is
you're asking us to say with respect to, you're saying is not related to, right?
We're saying with respect to means that it's a requirement that has to do with the designation of that. Yeah.
Or the actual use. Okay.
Yeah. But I think
has the FCC said anything about these provisions you're interpreting?
I'm not aware of that, Your Honor, but I want to also point the court to 531C, which says a franchising authority may enforce any requirement in any franchise regarding the providing or use of such channel capacity, and such channel capacity is PEG channel capacity. So this is a different phrase. This is
yes, but the next sentence says such enforcement authority includes the authority to enforce any provisions of the franchise for services, facilities, or equipment proposed by the cable operator. Are you saying that that is not a limitation on the first sentence?
Yes, we think that any requirement regarding the providing or use of channel capacity, and then the including is just an identification of a specific area that is going to fall within that.
Okay, but any requirement would seem to refer to the franchise agreement itself, and none of these franchise agreements include any of the state of Maine's PEG provisions. So
Right,
I don't, I understood your argument to be, oh, we're authorized under 531C, but I'm doubtful about that.
Sorry, just to be clarified at this point, I took your argument to be 531C shows that 531A is not exclusive of the authority. So if there's background state authority, 531C is contemplating its existence.
That's correct, Your Honor. Our argument is that, and I think this is where this is just really like a fundamental difference between us and the appellant, is I think that the appellant's view is whenever we do something that relates to cable television, we have to look for some authority to do that in the Cable Act. And our point is that that's not true, that the state has retained its inherent police powers, and it can regulate cable television just like any other matter, so long as it's not preempted by the Cable Act. So so that would mean that you have to look at the Cable Act, and of course, like one of the first issues is it consumer protection or isn't it, because there's two different preemption provisions. But our view is that we don't need to find some affirmative source in the Cable Act to show that we have the authority to do this. NCTA has to show that there's something in the Cable Act that would conflict with what we're doing or that would specifically preempt what we're doing. And the issue of sort of—
excuse me, you know, one of the frustrations in this case is reference to broad policies as opposed to the text of the act. And so I don't think those statements advance the cause very much. They have provided to us a series of different provisions, which they say are preemption provisions, starting with the adequacy, and then as to each of the three, they go into them. So maybe you ought to address that.
Sure. So I mean, I think I've already said, so the first provision that they rely on, and they say that this provision preempts all of the PEG provisions, is 531A, which talks about how a franchising authority can only establish requirements with respect to the designation or use of channel capacity if it's set forth in that section. As I argued before, our view is that the PEG requirements don't relate to the designation or use of channel capacity. So that section does.
I can understand designation, but use is a very, very broad term.
Well, Your Honor, I think even NCTA agrees that use means third-party use, because this issue came up in the oral argument with respect to another section, to section 531B. And this was a question that the district court judge asked me, because she looked at 531B and saw that a franchise authority may require rules and procedures for the use of the channel capacity designated pursuant to the section. And she said, it seems to me this is a slam dunk for you because this relates to the use of channel capacity. And to be honest, that question caught me a little bit off guard, but the way I read that provision, it's the use of the channel by the people who are going to be using it. And NCTA's lawyer agreed, at least for purposes of 531B, NCTA's lawyer agreed that use there means use by third parties. So I think it'd be unlikely that Congress meant something different when it used use in 531A than what it used in 531C.
I'm sorry, but does that advance the cause if it's with respect to use by third parties? Just about every one of these provisions seems to be with respect to use by the subscribers.
Well, I think the point is that the district court judge was suggesting that use is very broad, and so use would mean, for example, that something that says you have to show them in HD would be a use of the PEG channel. Obviously, that argument would help us, but I think both NCTA and the state agree that use in this context means how are you going to set up the rules? Like how are people going to become eligible to use the PEG channel? what kinds of organizations are going to be allowed to use it.
But I think as opposed to where it's located, information about it, etc.
Yes.
Okay.
And I think we said this,
yeah. Could you go to 541 then? An adequacy.
Yeah, and if I may, Your Honor, just before I leave 531, I just want to say that the idea that franchise authorities can't do anything more than just say you can have we want 3 PEG stations, that would mean that a cable operator could say, okay, we're going to give you a postage size stamp television station that is, in the 8,000 range and is going to be shown in black and white. So there has to be, it would be ridiculous that Congress thought that franchise authorities can't say something about how these stations are going to be displayed. So with respect to 541, Your Honor, which refers to adequate capacity. So that one says that franchise authorities can require adequate assurance.
5 minutes remaining.
That the cable operator will provide adequate public educational and governmental access channel capacity, facilities, or financial support. And our view is that the PEG requirements aren't any of those things. So channel capacity is just how many channels are there going to be. Facilities is things like what kind of equipment or broadcast studios are you going to require the cable operator to provide. And financial support is, are you going to give some money to the town so they can televise their local town? So that's point one. Point two, and I know this issue came up before. Our view is there's a difference between what a franchise authority can do and what a state can do. Congress clearly knew how to distinguish between the federal government, franchise authorities, and the state when it drafted the Cable Act, because you'll see different provisions. Sometimes it'll say neither the state nor a franchise authority can do something. Other times it says neither the federal government nor the state nor a franchise authority can do something. So just as sort of a broad point.
Yeah, but isn't this where the FCC interprets the statute to say, if the locals can't do it, the state can't do it either. The preemption extends that far. And what's wrong with that reading?
Well, first of all, I'm not sure that, I could be wrong, but I'm not aware the FCC has expressly said it that way.
Well, that language is certainly in an FCC opinion, but mind you, the opinion dealt with different issues than this.
Yeah. And I think the problem with that is, and I don't know how to say it any differently, is that if you just look at the Cable Act, for example, the provision that relates to the content or provision of cable services, I think it's 546. That one says the federal government can't do it, the state can't do it, and the franchise authority can't do it. There's some other provisions that talk about the state can't and the franchise authority can't. If Congress had wanted to say that a state can't do something and knew how to do it, and it would have included it whenever it was referring to what a franchise authority can't do. So I just don't think you can come away.
Yeah, but it doesn't make sense to me that Congress intended for the state, as a matter of state law, to require franchise authorities to do things that Congress preempted. That just doesn't make sense to me.
Well, I think states stand in a different position than most franchise authorities. Admittedly, states themselves can be franchise authorities, but I thought I suspect that Congress thought it was important to preserve state authority, and that's apparent from the 2 preemption provisions. And so I think if Congress really wanted to stop a state from doing something, it would have said so.
If you do it through the franchise authority, there is a contracting quality to it. Whereas if you do it outside the franchise authority, it's a regulatory exercise, which has a different political dynamic. And so you might have thought they were tending to distinguish between the exercise of contracting power and regulatory power.
I think that's exactly right, Your Honor. And also, to be fair, I think a lot of franchise authorities, especially in Maine, they're very small, very local. I think Congress may not have wanted to have given them as much authority to include provisions, but instead wanted to sort of leave it to sort of a more accountable entity like state government.
Could you go through this 541, just like it was helpful to me when your opponent went through each of these provisions as Judge Lynch was having her do. So the next one up is 541. You just explained why I guess you just finished 541. The next one up is 547.
I'm sorry, Your Honor, I didn't mean to interrupt. I was just going to say that the only thing I didn't add about 541, and I won't repeat it because it's in our brief, is that even if 541, the adequacy applies, we don't think that we're going on beyond requiring what is adequate.
Then now that 531, as I understand it, and 541 are sort of the general claims of preemption that cross-cut all three requirements. And they've got specific provisions that go to each of the main requirements. So can we just walk through those? Maybe start us with, I don't know, you take your pick as to which one you want to start with.
Why don't we start with 544E, which talks about how the FCC is charged with prescribing regulations to establish minimum technical standards relating to cable systems technical operation and signal quality. So point one is that NCTA keeps suggesting that HD and SD are a signal quality issue, but there's no support for that in the record, in the statutes, in the FCC regulations.
If we disagreed with you on that, and if we thought that it would be a problem if they had required PEG channels to go out under HD, even for cable operators that didn't have any HD channels at all, is there some argument that nonetheless this type of regulation does not implicate a technical standard, a minimum technical standard for HD quality when it applies only to those cable operators that do have HD capacity and are putting out programming that they receive in HD signal quality from PEG channels?
Yes, because we're not imposing some new technical standard. We're not saying that you have to show all stations in ultra 4K.
Can you address the record-based point that your opponent made on that exact issue? As I understood it, she was saying that's not true because there is a technical difficulty in receiving the HD signal programming from the PEG operator to the cable operator.
Yeah, so this is going to involve me going a little bit outside the record because this is an issue that came up in sort of discussions with NCTA's counsel when we were trying to reach a resolution of an injunction pending appeal. And so I don't think you'll see this in the record, but I don't think, and certainly if my opponent wants to correct me when she gets up again, she can. But the way that the main statute is designed is it's supposed to say you don't have to help these PEG providers produce their programs in HD. It's just if they're putting it out in HD and it's coming to you in HD, then you've got to pass it along in HD without degrading it. As it turns out, and I think this is something that maybe we weren't aware of when we initially briefed the case below, when we briefed it in the district court, is that the cable companies have installed the equipment at the PEG studios. And so the feed goes into the equipment in HD at the PEG studio, but then it's the cable operator's equipment, which is located in the studio, that then sends it to the head end, as my opponent explained. So we think this is an issue that may have to get litigated separately, because the issue is if it's your equipment in the studio and it's coming to that equipment in HD, then our view is you have to send it along in HD. I think maybe the cable operator's argument is no, just because we supply that equipment, and I think they might supply it under the terms of the various franchise agreements, we don't have to upgrade that equipment. But again, our view is it's their equipment that's causing the problem. And so if they have to upgrade their equipment to get it to the studio, then that's their responsibility.
I'm both glad and asked you that question, but
I have a fact question. There are commercial channels and presumably some type of commercial education channels that must transmit in HD. Okay, so why did the cable operators not have a problem there, but they have a problem with the PEG channels?
Well, that's a great question, and I can tell you what I think the record fairly reflects, which is look, cable operators by law have to provide PEG stations, but they don't like them, and I think they even acknowledge that in their complaint, where they say we would prefer to provide other content because they don't make direct money off the PEG stations. So they have to carry them, in name only. And so what they've done is they've done everything possible to minimize them, to make them so no one wants to watch them. And so eventually maybe they won't have to carry them anymore. So, you know, they refuse to show them in HD, even though over 300 other channels that they have are all in HD. Their argument they don't have the bandwidth doesn't pass the straight face test. They move them to this range of stations which no one ever goes to, and they actually claim this was done to help people find the stations, that it's much easier to find them when they're moved to these places. And then they don't provide any information.
Counsel, thank you, Judge Barron.
Go to the next provision is the question about the channel placement. And that implicates the effective competition provisions in 543(7)B, if I've got it right.
Yeah, and you know, Your Honor, as you were asking your questions and I was looking at it, you know, I realized that perhaps we should have made a different argument on that one, or an additional argument. You know, certainly at least one federal court has interpreted that as saying that only cable systems that are subject to effective competition are subject to this tier provision. But you know, I do see the argument that there's nothing in the statute that actually says that. It says all cable systems have to provide PEG on the basic tier. And so I think one way of looking at the statute is to say what Congress was doing is it was sort of starting out with, this is what the basic tier is going to be for everyone. And then it was saying, and then this is how we're going to regulate the rates for that basic tier. I'll be upfront and honest, we did not make that argument in our brief. We just sort of assumed that what the federal court said in the other case was accurate. But I completely agree, Your Honor, that there is a real question there about whether or not this requirement applies to all cable operators.
Okay, then the last issue is the electronic programming guide. And Judge Lynch or Judge Burroughs may want to ask about the information services part of it, but and I understand there's a dispute about whether it's covered. But can you explain to me why it's not the regulation of the content of a cable service? I'm having trouble seeing how it isn't.
Yeah, so I mean, I have a couple of responses to that. I mean, I think the first is the intent was that of 544 F1 was to make sure that neither the states nor the federal government nor franchise authorities were dictating what kind of programs or channels were going to be offered or not offered. But
could you just, how would you read the text to draw the following distinction? Presumably, you cannot, as a franchise authority or as a state, mandate that on the electronic programming guide you set forth elaborate reviews of how good the programs are, because that would be the regulation of the content of a cable service, even though it's a channel guide. So that being the case, how am I supposed to read the word content that would nonetheless allow the regulation of this particular type of content?
So I think one way you could do that, Your Honor, would be to say that, and I think there's sort of two issues, because there's first the issue of at least just putting the name of the PEG station on the guide, right? Because right now they just say local and that's it. So I think at the very least, I don't see how anyone could say that just saying Portland WCBT 6, I don't think that's content. I mean, that's just an index entry in a database, essentially. So I think that's clearly not content. And then, you know, also saying just what the name of the show is that's playing at a particular time, we would say that's not anything content either. Again, that's just one step down from an index of what's on. I mean, you know, certainly we can't tell them that when you're showing a football game, you have to, you know, describe, you know, what happened the last time the teams met or who the main players are or anything like that. But certainly just giving the basic information. I mean, this is like, you know, people can't find stations without the program guide. I mean, this would be like a library deciding that they don't want people looking at a particular category of books, and so just taking those books out of the card catalog, and just having people have to hunt through the shelves to look for the books. Yeah,
one last turn on this is just, if the card catalog is the equivalent of the cable service, then saying what is on the cards in the catalog is the regulation of the content of the card catalog. So regulation saying what the electronic programming guide says would be regulation of the content of the cable service. That's the difficulty I'm having textually.
So I don't know if this is what you're saying or not, Your Honor, but I would say that the books in the library are the content, and the card catalog is just a way of finding them. So I would say the card catalog itself is not the content. But the other point I want to make is that when it comes to PEG stations, states and franchise authorities can regulate the content of those. I mean, that's one of the exceptions to content regulation. So if states can regulate and franchise authorities can regulate what's on the PEG stations, it would seem it would seem ridiculous that we can't also regulate that there be an entry in the program guide saying what's being shown.
Mr. Taub, you're not going to be surprised by this next question, which I'm also going to ask your opponent. Is there any point in asking the FCC its views on at least some of these preemption issues? Have you all tried?
No, Your Honor. We've taken, and I'll be honest, I don't do a lot of this kind of regulatory cable type work. I don't know how the FCC operates in practice. We haven't talked about it before. It's something we'd be willing to think about for sure.
But well, it's not unheard of for this court to ask a government agency to file an amicus brief setting forth its views. We've done that more than a few times.
Yeah, I mean, certainly that's the court's prerogative. I've been involved in cases where the court has asked for the federal agency to weigh in. Again, though, I think here there's just really no reason for the FCC to weigh in. I think this is straight statutory interpretation. I think, yes, the FCC does bring some expertise to bear, but I think in these issues, I really think that that the court can interpret the statutes just as well as the FCC can.
Well, gosh, that's sort of being complimented with the left hand, but thank you. All right, we'll hear from your opponent.
I'm sorry, Judge Lynch, you asked about the line authority and the effect of the unreasonableness standard, and I just wanted to hear, Mr. Taub, your response to that. I know there's the particular issue of the line authority, but I really think it's a global claim about how to understand the act, which is that all regulations by franchise authorities or states imposing them must come in the form of a limitation that they not impose unreasonable costs, otherwise they'd be preempted. And if you could just respond to that, just to set it up, make it a little sharper on your side. I suppose the force of that argument relates to the burden shifting point, and there is a certain oddity that if we know that the renewal cannot be denied if you can show that the regulation that you're not complying with was imposing unreasonable costs, what is the sense in allowing regulations that up front don't even attempt to assess whether they would be imposing reasonable costs or not? So just if you could just address that set of issues.
And I will answer that question, Your Honor, but I just want to say at first that when it comes to line extension, we actually think, and we said this in our brief, that franchise authorities are entitled to do universal line access if they want to. And I think that the case and the FCC rules that NCTA is citing to, they're dealing with a different provision, which talks about giving a franchise to a second entrant into the market. So I just want to put that out there. But to answer your question, Your Honor, I think the first point is that this line extension requirement inherently has a reasonableness requirement built into it, because it talks about the build out in terms of homes per mile, 15 homes per mile. So that means that a very rural franchise area may not impose any kind of line extension because it doesn't meet that limit, whereas a more dense area that is going to apply there. So it sort of by definition is going to be tailored to how many customers are you going to end up being able to bring online if you extend one more mile of the cable service. But I think, and this goes to sort of the burden of proof, which is that NCTA agrees that franchise authorities can put line extension requirements in their franchise agreements, and they agree that states can mandate that they put certain line extension requirements in their franchise agreements. But they seem to say that the state can't impose just a one-size-fits-all requirement, that it has to somehow be tailored. Well, again, we think ours is tailored because we're not saying, you know, we're tailoring it based on how many people are going to end up being served. But the other point is that I think if their argument was going to prevail, they'd have to show that this is unreasonable in at least some context. I mean, as the district court said, she kind of flipped it and said they have to show that it would never be a reasonable requirement. But if they're going to say that our line build out is improper, they should have to at least offer some evidence that in some circumstance it's not going to be a reasonable build out requirement. And they've offered zero evidence on that. And then just the final point is, if it turns out that there is some area where 15 homes per mile for some reason is unreasonable, there's a process for that, as the district court set out, which is to do an as-applied appeal in that situation.
Thank you.
Attorney Taub, if you could mute your device at this time, and Attorney Ring Amundsen, please proceed.
Thank you. I'd like to just start quickly with where Mr. Taub left off, which was the line extension requirement and his contention that there's no evidence that it's unreasonable. In fact, all of Comcast's franchises in Maine and the vast majority of Charter's franchises in Maine currently include line extension requirements that are not nearly as onerous as the 15 homes per mile extension requirement. So there's evidence in the record that the vast majority of franchises in Maine would be subject to denial at renewal because they contain non-conforming line extension policies. And then just to turn to PEG quickly, we spent a fair amount of time talking about 531 and 541, and I just want to return to the district court's opinion, which found those provisions wholly inapplicable to the state of Maine. In fact, the court said that the state could regulate completely outside of those provisions because it was acting as a state and not as a franchising authority. And that sort of interpretation of the Cable Act would threaten the entire foundations of the Act. And just to look at how the court applied the 556C inconsistent preemption provision in the Liberty Cablevision case, that was a provision that applied only to franchising authorities. And the court didn't say, well, although the franchising authority is limited to a 5% franchising fee, this provision doesn't say anything about what municipalities can do, so municipalities are free to impose a fee on top of that. That's essentially what the state is arguing that it is allowed to do here. So
you're not making the argument, just so I'm clear, because sometimes it sounds like maybe you are making this argument. You're not making the argument that states are prohibited from doing things that franchises authorities are allowed to do.
No, Your Honor, we're not making that argument. We're not taking issue with the fact that a state has a choice. It can act either as a franchising authority or it can impose conditions on a franchising authority, but it has to always act consistent with the act.
The second thing is just on your preemption argument that arises from the reasonableness language in the renewal.
Mm-hmm.
If you're right, then how will the renewal provision ever come into play? Because the restriction to not be preempted would itself have to satisfy the renewal standard. If there was any gap between the two, you would say the restriction up front was already preempted. That doesn't make any sense.
Well, Your Honor, what we're saying is simply that when a franchising authority imposes a requirement on a cable operator, it has to be cost justified in light of community needs. So that the preemption argument is sort of a separate standard.
It has to satisfy the standard set forth in the renewal provision.
Yes, Your Honor, but something can still be inconsistent.
Then the renewal provision becomes irrelevant because anything that wouldn't satisfy it was already preempted before when they first enacted it. That can't make sense unless I'm missing something.
I'm afraid I'm not following Your Honor's question. So you're saying that if the line extension, that the renewal provision is sort of an independent preemption authority. That I don't think that's what we're arguing, Your Honor. We're simply saying that that what the main statute has done here is to impose a one-size-fits-all finding authority.
Ms. Amundsen, your brother says no. There's a clear distinction based on the 15 persons per mile. The more rural areas will not meet that. The more urban areas would. And there's no evidence in this record that as to that 15 number, that it is inherently cost ineffective as opposed to community benefit. And in the absence of such evidence, you cannot mount a facial attack. So what's the response to that?
Your Honor, our evidence is, as we stated, that every one of Comcast's franchise in Maine and the vast majority of Charter's franchises in Maine currently include line extension policies that are less onerous than 15 homes per mile. Every one of those would have to be denied when they come up for renewal based on the state's provision, with no finding about whether a 15 homes per mile requirement is justified in light of community needs.
The district court said you could have some as-applied challenges at that point.
Yes, Your Honor, but we think that's not what the provision intends. The burden is on the franchising authority to show that that's what the provision contemplates, is that the franchising authority must show that if it's imposing a requirement on cable operators, that requirement is justified by community needs in light of cost. Here, the district court flipped the burden and said that in every instance, it's going to be the cable operator who has to fight that battle.
Okay. Anything else?
The only other thing I just wanted to point to, Your Honor, is that Judge Barron, with respect, you asked about the interpretation of 531A, and I would just point you to the 1984 House report that we cite throughout our brief at page 45, where it does say that franchising authorities are limited to regulating PEG only as required in 531A. So, and we think that the district court erred in applying, in finding 531 and 541 just wholly inapplicable to these provisions, and then imposing them as consumer protection requirements on existing franchises.
I just one last on that point. If that would make sense if use was broad, is that right or not?
I'm sorry, I didn't hear that.
Is that because you would read use broadly to encompass these type of PEG requirements?
It could, Your Honor. Yes, the designation.
Then wouldn't that mean that all the PEG requirements are rules and procedures regarding use, and therefore they'd all be authorized by 531 itself? That seems the problem that you've got. I don't see how use can both help you in creating preemption, but then it becomes narrow with respect to authorization for rules and procedures. That doesn't make sense to me.
Yeah, no, Your Honor. And so I just want to be clear that the state has not, and neither the state nor the district court ever attempted to justify these under 531A or 531B. The state did attempt to justify these under 531C, which we think is a provision about enforcement, not a grant of authority to enact. So, so 531A and B don't provide authority for the state's enactment here.
One more question. Mr. Taub, when he was questioned about whether the guide is content or not, putting aside the index versus content, he says it doesn't matter because the content prohibition does not apply to PEG.
Well, Your Honor, we do think that it is both the provision or content of cable service. So it's regulating both the provision and content of cable service. And I just do want to point out that Mr. Taub seemed to say, well, look, would it be so bad to just make them put the station name there? But that's not what the act requires. What the act requires is that they be displayed in ways exactly the same as broadcast stations. And as we put in the record, that actually requires a lot of expense because of the hyper-localized nature of PEG. So you would have to have different programming guides in every different franchising authority, as opposed to most of the other parts of the guide, which are statewide or at least regional in nature. So that's not what the guide requires. And more importantly, it's not what that's not what the provision requires, and more importantly, that's not what Congress required. So we don't have to guess at what Congress intended. When you compare 531 and 534, 531, the provision regulating PEG, and 534, the provision regulating broadcast channels, what Maine is trying to do here is to import protections that are given to broadcast channels into 531 for PEG, and we don't think that's allowed. If the court has no further questions, we would ask the court to reverse the district court.
Any further questions?
No.
Thank you. Thank you both.
Thank you.
That concludes the arguments for today. This session of the Honorable United States Court of Appeals is now recessed until the next session of the court. God save the United States of America and this honorable court. Counsel,